People may steal the ideas and they will try to make a product.
Exactly. So people may steal and they might make money out of it. Like they'll make monetary benefits out of your own ideas. So you need to protect your particular idea or invention or whatever it is. So, for example, if it is copyright, what is a copyright? It is a right to copy something. So the right to copy something should be only to a particular person, right? Or to a particular entity. It can be a person or it can be a group of persons. So the right to copy should be within a particular person. That can be the original author or it can be transferred as well. So all these are the concept. All these comes under the concept of IPR. So now these rights are outlined in Article 27 of the
How about
UDH.
trademarks, ma'am? Trademarks also comes under IPR. Or?
Yes, trademarks are also coming under IPs. And trademarks.
Sorry to interrupt, ma'am. Are you sharing something? We still see IPR the first page, the blank page.
Oh, okay. I've actually moved to the second slide.
We don't
You're not
see.
able to see?
Okay, you're not able to see.
Okay.
Maybe you could stop share and start share again. So.
Okay, just a moment. What about now?
Yes, ma'am. We can see.
Okay.
Concept of IPR. We are seeing.
What about now?
Yeah, ma'am. You are able to see the slide is named as concept of IPR.
Has it moved? I've changed. I'm changing the slides. Are you able to see the changed slides?
No,
ma'am. No, ma'am.
No, ma'am.
Yeah, now you are in 40, slide number 41.
Yes, it is
Secrecy
changing.
and confidentiality in IPR.
You are on mute, ma'am. You are on mute.
Can you hear now?
Yes.
Yeah, yeah.
I'm really sorry.
Yeah.
Okay. So now you can see. So I'll keep this mode. I'll not keep to the full screen because people need to read. Okay. Okay. So we were talking about the concept of IPR, and we all know about the UDHR, and UDHR has 30 articles, and under Article 27, it provides for the right to benefit from protection of moral and material rights resulting from authorship of scientific, literary, or artistic productions. Everyone has the right freely to participate in the cultural life of the community, which is not relevant here, and to enjoy the arts and to share in scientific advancement and its benefits. So, UDHR, as per the UDHR, Article 27, everybody has the right to enjoy arts and to share in scientific advancement and its benefits. So, if you make an innovation, the public has actually the right to have some benefit out of it. But the economic benefits or the transferable rights, everything will be upon you. But still, it has to be released to the public for their benefit also. It is mentioned under Article 27. Now, secrecy and confidentiality in IPR. Confidential information may be a formula, plan, a sketch, or something similar which is developed by an individual out of the things available for common use by anybody. To constitute confidential information, which what is stressed on is the fact that the maker of the document must have used his intellectual effort and thus produced a result which can only be produced by somebody who goes through the same process. So I hope you understand that we are talking about trade secrets here. So are trade secrets protected under the IP rights in India? What is your understanding about that?
Basically chemical formulas, ma'am. So if you're making any products,
It can
right,
be
they may
chemical
have some kind of a formula.
formulas. Yes, it can be chemical formulas, or it can be even a business secret, right? It can also be a marketing strategy. It can be
Business
anything.
strategies. Oh, yes.
Yes, exactly. It can be anything. So these trade secrets, are they protected? They are not.
Maybe
So as
not. Not.
yes, they are not. You can actually go for a contract, but they are not protected under IP so far in India. So the proposition that information is regarded as confidential has four main classes, has been accepted, each of them being trade secrets, personal confidences, government information, and artistic and literary confidences. No registration procedures are involved for protection of a trade secret, and there is no specified time limit within which the secret may be protected. This is the case of India. When a trade secret is leaked out, this breach of confidence is an action that may be taken in a court, as this leak of the secret is unfair to the business or company and may have harmful consequences. So you can move a civil action. Okay, you can move a civil action if you have a particular contract based on the trade secrets. Now we look into what are some of the international conventions and treaties are under the IPR. So when we look into this, we'll have a better understanding on how the IPR works in India as well, and what are the national application procedures and international application procedures on IPR. So, which is why I went to international concept first itself. You'll have a better understanding. Now, the importance of IP was first recognized in the Paris Convention for the Protection of Industrial Property, which was in 1883, and the Berne Convention for the Protection of Literary and Artistic Works in 1886. Both treaties are administered by the World Intellectual Property Organization. So basically, there are two international organizations that control the IP internationally, which is WIPO and WTO. So WIPO came into existence before WTO. WTO came into existence in 1995, I believe, and WIPO came into existence in 1967, I guess. So WIPO is the most important international organization for the promotion of intellectual property worldwide. WIPO was formally created by the convention establishing the World Intellectual Property Organization, which entered into force on April 26, 1970. It was established in 1967. WIPO became a specialized agency of the UN in 1974. So most of these earlier conventions were under WIPO. Now, we'll look into the Paris Convention. There are 30 articles in the Paris Convention for the protection of industrial property. So there are, when we look into the conventions, there are many, most of the conventions would be strictly for certain particular IPs. Maybe it might be for the protection of trademarks, it might be for the protection of GI, or maybe combined 2 or 3 IPs. So this first convention was for the protection of industrial property, and it was in 1883, dealing with various aspects of industrial property like utility models, patents, designs, trademarks, trade names, false indications, and the protection thereof. Now, what we need to know are the basic three rights which are prescribed under the Paris Convention. So the provisions of the Paris Convention may be subdivided into four main categories. I would say three. The first category contains rules of substantive law which guarantee a basic right known as right to national treatment in each of the countries. So there are many contracting parties or contracting countries to this particular Paris Convention. And if a right, an IP right or an IP application, for example, patent or trademark, whatever it is, if the such a patent right is given, a patent is given to a particular person in a country, in a contracting state, the similar treatment should be given in other contracting states as well. The same treatment they would have given to their own people. Their own, I mean, for example, a person who has a patent in India should be given the same treatment in another contracting state of the Paris Convention. For example, if it is China or whatever it is, they should be given the same national treatment, whatever they get in China as well for that Indian person. I hope it is clear. So that is right to national treatment, basically. The second category establishes another basic right known as the right of priority. So when it comes to priority, there is something called as priority date in patents. We'll go deeper into that in the later sessions. Priority date is the first date. Okay, there are two applications. One is provisional application. Another is complete application in not application, specification in the patents. So you can either do the complete one first itself, or if you have the procedures, I mean, if you need to do a little more research or something, you can actually give the provisional application first itself, so that you can lock in the priority date. So the date, or if you have multiple patents, of a family of patents, then whichever patent you have applied for the first will be the priority date. So this is the right of priority, basically. When it comes to an international thing, if you have filed for a patent application in multiple nations, whichever nations you have applied first, that application date will be considered as the priority date. I hope it is clear. So this is the right of priority. So if I have applied in India, then there would be a date. If I am applying, if I am filing the application on 24/8, within almost 6 months or something, if I apply to another contracting state, maybe China or Africa or something, then not Africa, mostly they are developing countries. So if I am filing another patent application for the same thing or another similar thing, maybe a month later, the priority date would be 24/8. Okay, so this is the right of priority. And the third category defines a certain number of common rules in the field of substantive law, which contain either rules establishing rights and obligations of natural persons and legal entities, or rules requiring or permitting the member countries to enact legislation following those rules. So, and the third category is some other common rules which are applicable to patents, and all the different one. Some different rules are there to each of the patents or trademarks or whatever is there. So I hope it is clear. And another thing is an independent right is also there, which is it doesn't matter whether if I am in India and if my country has denied my patent in India, I can still apply for the patent in another contracting state. So the other contracting state of the nation cannot use this denial from my origin country as a reason to deny the right in that country. Is it clear? Should I repeat?
Clear, ma'am.
Okay, it's clear. So a fourth category deals with the administrative framework which has been set up to implement the convention and include the final clauses of the convention. So there are
Regarding the dates on the right of priority, ma'am, if the patents are something that is related to different subject, okay, in that case, will they follow the same date or how it be?
it is usually a family of sometimes it's a family of patents also you can call. I mean, it cannot be completely different subjects, but it can be something related. Usually, it will be for the same subject. It will be for the same subject.
Yeah, that is what
maximum.
I'm asking. If it is
Yes.
a other subject, then it will have a new date, right?
Yes.
Okay, thanks.
Okay. Now we look into the Berne Convention for the protection of literary and artistic works. This was in 1886. So the Paris Convention was in 1883. The Berne Convention was in 1886. So the Paris Convention was for, what was it for? Industrial property. This is for literary and artistic works. So these two are some of the prominent conventions which are followed applicable to the WTO as well. So Berne Convention, which was in Switzerland, it is an agreement to honor the rights of all authors who are nationals of countries that are party to the convention, to the contracting parties. Contracting parties. The convention is administered by the WIPO again. It deals with the protection of works and the rights of their authors. It provides creators such as authors, musicians, poets, painters, etc., with the means to control how their works are used, by whom, and on what terms. So basically, the moral and economical or material rights were mentioned in the Berne Convention to the artists. It is based on three basic principles and contains a series of provisions determining the minimum protection to be granted, as well as special provisions available to developing countries that want to make use of them. So again, in the Berne Convention as well, which was in 1886, there are certain minimum standards to be followed, and there are three basic principles, and then there are some common rules as well. So the three basic principles are principle of national treatment, which we dealt or which we actually saw in the Paris Convention as well, principle of automatic protection, and principle of independence of protection. The principle of national treatment and principle of independence of protection we've already discussed. Principle of automatic protection is something similar itself. It's just that if you comply with the basic conditions, you cannot be denied the rights. Okay. Now this is applicable to the literary and artistic works. That is the only difference. So it's almost similar principles. The other one, Paris Convention, was for the patents, trademarks, and all. This one was for the literary and artistic works. So what are the three basic principles which was mentioned in the Berne Convention? Principle of national treatment, principle of automatic protection, which is again, what is it? If you comply with certain basic conditions, you cannot be denied the protection in that contracting state. Then principle of independence of protection. So it doesn't matter if one of the contracting state, I mean, if the country of origin of the author, that contracting state has denied the copyright or not. It doesn't matter. You can still apply for a copyright in another country, but it is their discretion. It is the country's discretion to give or not give. So they may give, they may not give, but it is totally under their discretion. Now, another one is the Rome Convention for the protection of performers, producers of phonograms and broadcasting organizations, 1961. It secures protection in performances for performers, in phonograms for producers of phonograms, which are basically sounds, and in broadcasts for broadcasting organizations. WIPO is responsible for the administration of the convention jointly with the International Labour Organization and the UNESCO. Now, another important convention is TRIPS, Trade Related Aspects of Intellectual Property Rights Agreement, which was in 1995. Even the WTO was established in 1995. So I hope you understand that this is related to the WTO. Now, this was the first international attempt. Why this is important? So this was the first international attempt to address intellectual property rights as a whole. Okay, so everything under one umbrella. So this happened under TRIPS. So we can see that the Paris Convention was only for patents, trademarks, etc. And the Berne Convention was only for protecting the artists and the literary works and artistic works. And again, the Rome Convention, which was in 1961, what was that for? For protecting phonograms, etc. So now the TRIPS, it has made everything under one umbrella. So this was a comprehensive attempt to bring all the IP under one umbrella. So the copyrights, trademarks, patents, semiconductor integrated circuits, layout, designs, industrial designs, GI, and undisclosed information, everything came under TRIPS. TRIPS culminated at the end of 7 years of negotiations from 1986 to 1993 as part of the Uruguay round of multilateral trade negotiations of the GATT. So, be it WTO or WIPO, both have the headquarters in Switzerland. Both have the headquarters in Geneva, Switzerland. So, WIPO came much before WTO. So, since WTO, all the IPs have come, there has been attempts to make everything under one umbrella. Now, what is WIPO Copyright Treaty 1996? It is a special agreement under the Berne Convention that deals with the protection of works and the rights of their authors in the digital environment. So we know what the Berne Convention was about. Berne Convention 1886 was about. It was for the protection of literary and artistic works. So now they, under the WIPO Copyright Treaty 1996, they have extended to the digital environment as well. That's the only difference. And also, what is the period of copyright in India? Anybody? What is the period of a copyright?
20 years. 20 years.
20 years.
Yeah.
Are you sure? Is that
I
for
believe 12
copyright
years.
or is that for patent?
12 years for patent.
I beg to differ. It is actually for patents, it is 20 years. For trademark registration, it is 10 years. And for for copyright, it is actually 60 years. I mean, after the
lifetime, right? The lifetime.
Yes, it is there. It is applicable to the lifetime, and post lifetime 60 years as well. So
Yes, yeah.
after your death, 60 years also you can have the copyright. Not you, no, of course not you. The legal have the rights. So, but internationally it is actually 50 years. But in India, though it is 60 years, internationally it is the lifetime plus 50. So any contracting party, even if it is not bound by the Berne Convention, must comply with the substantive provisions of the 1971 Act of the Berne Convention for the protection of literary. There is something wrong in that. Okay, sorry. Furthermore, the WCT mentions two subject matters to be protected by copyright: computer programs, whatever the mode of form of their expression be, and compilations of data or other materials or databases in any form which by reason of the selection or arrangement of their contents constitute intellectual creations. So basically it is actually expanded to the digital era as well, digital sphere. Now some of the international applications. One is the Madrid system, which offers the possibility to obtain trademark protection in the countries of the Madrid Union. So, there has been Madrid Protocol, which was convened in Madrid. So, this is for the international applications filings on trademark. Okay, protection in the countries of the Madrid Union by filing a single international application. We will go deeper into it when we go to trademarks. Then another one is any national or resident of a PCT contracting state can file an international application for patents. So for patents and trademarks, we can actually file international applications. We'll go deeper into it when we learn about trademarks and patents. Now, IPR and criminal jurisprudence. So one of the consequences of governmental involvement in IP issues is the criminalization of IP use and exchange. So why do you think there should be an involvement of criminal jurisprudence in IP? It's actually kind of a theft, right? If somebody infringes your right or if somebody steals your particular invention, it's kind of a theft and kind of a crime. So items covered, if we have, if the tangible property items are covered in the criminal jurisprudence, why not the intangible ones as well? So items covered under the IP legislations, especially in India, are identified and protected because of the public interest involved. According to the Copyright Act 1957, any person who knowingly infringes or abets the infringement of the copyright in a work or any other right conferred by the act is treated as an offender. He is punishable with a minimum of 6 months imprisonment, which may extend to 3 years, and a fine between 50,000 rupees and 2 lakhs rupees, according to section 63 of the Copyright Act. So there can be a criminal action and there can also be a civil suit filed. According to the provisions of the code, as it was enacted in 1860, using false trademark with an intention to deceive or injure any person was an offense punishable with imprisonment and fine under section 480 of the IPC. So these are some of the influence of criminal jurisprudence in IPR. So I hope this particular chapter is clear to you. We were dealing with IPR, what IPR is, what are some of the basic rights, how it is, how it is viewed internationally, what are some of the important conventions. We dealt about the Paris Convention, Berne Convention. Paris Convention was in 1883, Berne Convention 1886. And then what else? Anybody? We talked about the TRIPS. We have two main international organizations, which are WIPO and WTO. Most of the other conventions were under the WIPO and WTO, World Trade Organization. The TRIPS come under the WTO. So these are some of the TRIPS was the first international attempt to bring all the IPs into one, to have a comprehensive, not legislation, convention. And we looked into the relation of IPR and criminal jurisprudence. So these are some of the basic things you need to know in the final chapter. We'll take a break now. Is that fine?
Sure.
Okay. I'll come back in 10 or 15 minutes. Thank you.
Guys, what happened?
We are on break.
Hi everyone. Is the
Hello.
screen visible?
Yes,
Yes,
ma'am.
ma'am. Trademark.
Okay, fine. Just a moment. I'm sorry. Okay, so now we'll look into trademarks. Now we have an idea about IPR, what the different IPs are, what are the basic rights that are conferred on the people who apply for the IPs, IPRs, and what are the various conventions regarding the IPs. Um, Now we'll start learning each of the IPs. First, we'll look into trademarks. Trademark is comparatively one of the easiest IPs to learn. So here we'll learn about the Trademark Act and what is the definition of a trademark and why we need to register the trademark and what are the consequences if you don't register a trademark and what are what's the tenure in India and what are the international application process, national application, and what else. We look into the rights conferred and what happens when it is infringed, and we look into the doctrine of dilution, and then we look into the idea of distinctiveness while registering a trademark. So these are the things which we'll be looking into with respect to trademark. So what is a trademark? What's your idea about trademark?
It's basically a sign or a logo kind of thing for doing the business, or
It's
basically to identify the
basically, yes, exactly. So it's
identify the
basically a sign. It can be a logo. What all can be a logo? What all can be registered as a trademark? Can anything be registered as a trademark?
no.
Definitely not. So we have certain restrictions even on registering the trademarks. Not everything can be registered as a trademark. You can still move on with having the trademark, but it shall not be registered. So if it is not registered, you cannot file an action suit. And then there are two different types, basically two different types of trademarks. One is collective trademark and certification trademark, and the normal trademark as well. So we'll look deeper into all these now. So a trademark in layman's language. So what is the act which is dealt under trade, which deals with trademark? The Trademarks Act 1999. So before that, we looked into the international application just superficially on trademarks. Do you remember um, what agreement or what system that was? We talked about two systems. One was PCT applications and one was Madrid. So which one was for trademark? We just learned that. For international application, it is Madrid. Okay, we'll look into that deeper now. So coming back to trademark, trademark in layman's language is a visual symbol, which may be a word, signature, name, device, label, numerals, or combination of colors, or combination of all these by one undertaking on goods or services or other articles of commerce to distinguish it from other similar goods or services originating from a different undertaking. The selected mark should be capable of being represented graphically, that is in the paper form. It should be capable of distinguishing the goods or services of one undertaking from those of others. So now marks include, according to the Trademark Act, a device, brand, heading, label, ticket, name, signature, word, letter, numeral, shape of goods, packaging, or combination of colors, or any combination thereof. So these all are included under the term mark. The trademark regime has now seen the emergence of unconventional forms of trademarks such as smell, sound, and taste marks. Have you heard about the sound trademark? Anybody?
Maybe songs composed by a musician.
Songs composed by a musician, that will come under copyright, right?
Okay.
How do you think a sound can be trademarked? Okay, I'll give you an example. Have you heard the tune of IPL?
Yes.
That is actually a trademark. And I don't know if you remember, there is this MGM channel. Before cartoons and all are played, there is this particular logo of a lion roaring for the MGM channels. So that particular roar of the lion, it is actually a trademark as well.
Which means, shall we call it as interchangeably as a copyright?
No, it is exclusively a trademark. That's not a copyright. Okay.
Trademark will be the same, but right, ma'am? So trademark will be the same kind of a music that can be used on different occasions.
Not different occasions. Definitely not different
I mean,
occasions. Why do you?
not different,
why
I
do
mean,
we
not
need
occasion, not different occasions. I mean, to on a specific occasion.
And if okay, if it's not also occasion, it is exclusively to identify or to distinguish a product from another. Okay, so the basic thing you need to understand about trademark itself is this particular function. So why do we need trademark? It is to distinguish something from another. So there would be multiple products from different undertakings, right? So the same product from different undertakings, we need to distinguish each of them, right? So for that, we need a particular mark. So we can distinguish based on the sound, we can distinguish based on the music, the smell, even smell, or taste marks. All these unconventional forms of trademarks are there as well. So for IPL, that particular sound, if you hear, you know it is the trademark of IPL, or they are talking about IPL. So when you hear that MGM channels, that roar of the lion, you know for sure that that particular MGM channel is on the screen. So it is to distinguish one from another. So it is not a copyright, and it does not cease to exist. Like a trademark has almost kind of perpetual existence as long as it is
name,
renewed.
ma'am, the name, basically, for example, so if you take the movie of Rajini, right? So basically, when they are trying to display his name, they will give a background music, right? So
Background music, yes.
Yeah. So that is a trademark, or
that is not a trademark. That is a copyright. Okay, that is a copyright. There is a difference there. Am I clear here?
Okay, so in Singapore Airlines, they used to like give some perfume. So that is a trademark or copyright?
Singapore, what Singapore?
Airlines inside the airlines, Singapore Airlines, they use, right? So we shouldn't use anywhere in the world that aroma.
Okay, if I'm not sure about that one, but if it is there, if it is mentioned that it cannot be used anywhere, then definitely that is a smell trademark. Okay, that can be taken as an example for smell trademark. But I'm not sure about, I've not heard about that one. So I'll look into that and confirm and tell. But if you already know that it cannot be used anywhere else, then it might be a smell trademark as well. Okay.
Okay. Yeah.
Okay. So now we know what a trademark is basically. So now we need to know why there need to be a trademark. Why should there be a trademark? One is definitely to distinguish one product from another. What do you think?
Uniqueness.
Uniqueness.
Yes, very good. Uniqueness. To maintain the uniqueness, then
Marketing.
marketing. Very good. Marketing is another function.
Other companies are not supposed to misuse the same.
Yes, to not have benefit of another, right? So so to make sure that for example, if I if I manufacture a product under the name of Apple and people try buying that, people might be thinking that it is the original Apple product, right? Exactly. So to make sure that others do not receive or live from the benefit of another brand. Then anything else? I think we've actually covered most of the functions. Very good. So now, according to section 21ZB of the Trademarks Act 1999, a trademark means a mark which is capable of, we've actually looked on the definition of mark already. So now trademark is a mark which is capable of being represented graphically and capable of distinguishing the goods or services of one person from those of others, and may include the shape of goods or their packaging and combination of colors. So this is the definition for trademark under the Trademarks Act 1999. Now we'll look into the functions of trademarks as already discussed. It identifies the goods or services and its origin. It guarantees its unchanged quality. So if we buy from Adidas, we know that product will be of good quality, and not just that particular product, any other products that they might that they might manufacture in future, we know that those products would also be of a particular good quality to a great extent. And then it advertises or markets the goods or services. It creates an image for the goods or services. So when you see a particular trademark, you know for sure that this particular trademark is talking about this particular product. Now, what are the types of trademarks? One is product mark, service mark. They are under class number 35 to 45 in Schedule 1 of the Act. Then there are service marks come under classes 35 to 45. Product mark is another thing. And then there are collective marks. Product mark are the trademarks for certain products. Service mark are for the trademarks for certain services that you render. Now there are collective marks. There is certification mark, shape mark, sound mark, pattern mark, etc. But the main things you need to know is are collection mark and certification, collective mark and certification mark. What do you think a certification mark would be? It is there in the term itself. Product mark and service mark, we understand. They are for certain products. That particular product's trademark, that particular services trademark.
Specific to any certificates that we receive.
ISO kind of thing.
Exactly. Both are right. So they are some ISI, ISO, BSI, all these 916, all these things are certification marks. So they ensure that particular product will be of certain good quality. Now, what is a collective mark? What might be a collective mark? What do you understand from that term?
It may not be as you said, right? It's other product, but the same brand. You can say like Nike or Adidas you mentioned, right? So it's not only particular product; it will be a collection of under their particular logo or particular
Okay.
brand.
Okay, I understand how you got confused there, but collective mark is not about that particular products. Okay, all those things come under the product mark itself. Okay, so product mark and service mark are actually for the products and services. Those are covered under those exclusively. Now, certification mark, what is that? They are giving some sort of certifications. They're certifying that the products would be of certain quality. Now, collective mark is actually, for example, ICSI, they have a trademark. What is that? So if you're from, if your profile shows that particular trademark, it shows that you're part of that collective group of people. It is mostly used in used by a certain professionals or group of people or associations, etc. Okay, so if you have that particular collective mark, it shows that you belong to that particular collective. You belong to that particular group. Am I clear?
Okay, yeah, got it.
Okay. So
Any
there is
example, ma'am, for collective marks? Any
ICSI,
example?
company secretary. So if you have the trademark, I mean, if you have that, if that ICSI, have you seen that logo?
No, ma'am.
Okay. So if you go to the ICSI page, you can see that particular logo. That is actually a trademark. It is actually a collective mark. So it means that you belong to that particular group. You belong to that particular group of company secretaries. We have ICSI, right? It is the collective group for the company secretaries in India, or for chartered accountants, for CAs also they have collective mark. Okay.
Okay, thanks.
I hope it is clear. If you have any doubt, you can ask. Now we look into the distinctiveness of trademarks. So we need to know about the distinctiveness of trademarks, because or else we'll not able to understand whether a trademark is registrable or not. So you can have a trademark, you can move on, you can move forward with, you can move forward with your business even if your trademark is not registered. But the thing is, your trademark won't be protected. That is the only problem. But if it has to be registered, there are certain conditions to be followed. So there are different types of trademarks based on the spectrum of distinctiveness. So how distinctive your particular trademark is? The 5 categories are: 1, generic, descriptive, suggestive, arbitrary, and fanciful. So what is generic? It is written actually on the PPT itself. So generic is a common term that fails to distinguish one product source from another. That is the exact thing what the product is. So if I am in the manufacturing of what do you say, tables, if I am in the manufacturing of tables, and if I try to register the term table as my trademark, would that be possible? Definitely not. Okay, so that would definitely be not possible because it is very generic. I am into the manufacturing of tables, and if I keep tables as the name of my manufacturing company or whatever it is of tables, you cannot get that registered. So it is not protectable under the Trademarks Act. Now another one is descriptive. So words that reflect the nature, quality, or contents of the product. So it is not talking about the product. The trademark is not talking about the product as such. For example, um, uh, four legs, something like 4 legs. So if I am into the manufacturing of tables, if I give the term 4 legs or 4 legs wood or something like that, it actually is sort of a description about the product, right? Not the exact product, but it is actually you're giving a direct description of the product. So that can also be not registered, but sometimes it might be registrable based on whether, if it has a secondary meaning or something. Now, suggestive marks are a word or phrase that hints at a product's attribute. So, for example, if
coffee box is there, so you can say, you shouldn't say taste.
Pardon?
Coffee, Starbucks or coffee, you cannot mention as taste, something like that.
Yeah, maybe, yes, maybe you can say like that also. Or if we take table itself as an example, you cannot just trademark, you cannot register a trademark such as study table, right? You cannot just or study co or something like that. You cannot register a trademark for a study table. So it actually suggests that this table is for studying, right? So you cannot just directly or indirectly, what to say, you cannot just, I mean, they can be protected, but sometimes the registry would reject it. So generally they are protectable, but it is not usually suggested. Now, another one is arbitrary. Arbitrary is a common word used in an unrelated context. So it is actually, for example, if I keep again, if I take an example of table itself, if I keep what do I keep as astronaut? If I'm keeping astronaut is actually a term which actually exists, right? So if I try to register the trademark astronaut for my study table, it can be registered because it is actually an existing word and it actually does not mean anything. It is not related to the study table at all, right? So it is an arbitrary, but it is definitely protectable. And then there is fanciful, wholly invented sign, symbol, word, or phrase. The examples are Kodak. Do you have any other examples? For example, it's fanciful means you actually create a whole new word itself. So it does not exist at all. So it is completely new to the world. So that is definitely protectable. So it can be easily registered as well. Do you have any other examples for a fanciful trademark? Anybody?
Ford,
Ford. There is no other term. Ford.
I don't think so. Ford.
Yeah,
How
I
about
think.
Byju's, ma'am? Byju's.
Baiju is actually a term, right? I mean, it's actually a name. So Baiju can be arbitrary.
Tesla, ma'am.
Actually, Baiju's will not be arbitrary as well because it is suggestive. Why is it suggestive? Why do you think it is suggestive? It actually hints at the product's attribute. That is, it is actually taught by Baiju, right? So it was actually started by Baiju. So it is suggestive of an attribute of that product. So Baiju's would be a suggestive mark. Anything else?
Tesla.
Tesla. There is no other word Tesla, right?
Yeah.
Tesla codes are not there. Okay, if it is not there, then it is a fanciful one. Anything else? Apple. Where would Apple come? The phone company
Descriptive.
Apple.
Descriptive.
Are you sure? Is Apple a word?
No, sorry, arbitrary. Arbitrary.
Very
sorry.
good. Arbitrary. Yes, it will be arbitrary. Anything else? Anything else you have? We can try this. Any other trademarks that you'll have to, you'd like to try? Okay, Samsung. Where would Samsung come? Think and tell me, where would Samsung come? Is it generic? Is it descriptive? It's okay if you are wrong. We are here to learn. Is it suggestive? Is it arbitrary? Or is it fanciful?
It can be a fanciful because it's a Korean. We don't know the literal meaning of it.
Oh, is it Korean?
Yeah, Samsung is from
Sams-
Korea.
Yeah, that I understand. But is there a word Samsung? I don't think so. I believe it is fanciful.
Yeah, it's a guess only. We might not know that.
Yes. So if there exists a Korean term, then it is definitely arbitrary. But if it does not exist, then it is a fanciful term. So I hope it is clear to you what the types of trademarks are based on the distinctiveness. So there are almost 5 types of trademarks based on the distinctiveness of the trademark. Those are generic, descriptive, suggestive, arbitrary, and fanciful. So the more distinctive the trademark is, the more chances they will be registered and they will be protected. So the more descriptive they are, the less chance for getting it registered or protected. Now we look into the Madrid agreements. So there was this Madrid agreement and then there was Madrid protocol. So the Madrid agreement was adopted in 1891 and it came into force in 1893. So the Madrid agreement was basically, for a global trademark, for facilitating the centralized application of a global trademark thing. So the Treaty of the Madrid System. So what is Madrid System? So there was this Madrid agreement first, and then some changes were made, and the Madrid Protocol was there. So Madrid agreement together with the Madrid Protocol is known as the Madrid System. So Madrid Protocol came into existence in 1989. Madrid Agreement was adopted in 1891. So the combination of the Madrid Agreement and the Madrid Protocol is known as Madrid System. So the need for the Madrid Protocol was some changes were made to the Madrid Agreement. What is Madrid Agreement based on? It is for the registration of trademarks internationally and for for the rights, for controlling the rights on the people who hold the trademark registration. The special provisions relating to protection of trademarks through international registration was made under the Madrid Protocol. So, looking into the Madrid Agreement. In the agreement, only states have the accession whereas in protocol, both states and intergovernmental organization have the accession. Fees in the agreement is basic, complementary, and supplementary, whereas in the protocol, the fee system is basic, complementary, and individual. The refusal period under the agreement is 12 months, whereas in the protocol, the refusal period is 18 months, which may be extended. So these are actually the difference between the agreement and the protocol. And the dependency period under the agreement is 5 years, whereas under the protocol is 5 years with the possibility of transformation. That is under Article 6 of the protocol. Validity under the agreement was for validity of the trademark was for 20 years, and the validity of the trademark under the protocol was for 10 years. Choice of office of origin in the agreement is real or effective industrial or commercial establishment, whereas choice of office of origin is the first nation you apply the trademark for or register the trademark for, whereas under the protocol it is the establishment, the domicile of origin. Now we need to know about the dependency period. What is the dependency period? The dependency under the agreement is 5 years, and also under the protocol is also 5 years. So dependency period is nothing but for under 5 years there is this office of origin, right? So where you file the application first itself. So when you file the application first, that office of origin, if they reject your application, not reject, if they cancel the application within the dependency period, that is the 5 years, then it will be applied internationally also. But after 5 years, if the office of origin cancels, or you forget to renew at the office of origin the trademark, then it will not affect the international application or the international registration of the trademark. So within the dependency period of 5 years, if anything happens to your trademark at the office of origin, where in that particular country, if something happens to your trademark, then it will affect the international registration as well. Am I clear? I hope I am clear. So that is what is dependency period basically. Now we'll look into what is doctrine of dilution. What do you think doctrine of dilution would be? What is dilution? What is dilution basically? It's kind of an adulteration, right? So there is something of original quality and you're actually diluting it. So you're actually tampering with the originality of something. So you're tampering.
Creating duplicate.
Yes, creating duplicates. So you're actually causing a problem to the original mark. That is basically doctrine of dilution. So one of the famous cases on doctrine of dilution is ITC versus Philip Morris products. It provides for a basic understanding of the trademark dilution cause of action in India. So I could, while referring to section 29, clause 4 of the Trademarks Act 1999, held the dilution cause of action established that the following essential elements are satisfied. One is impugned mark. The questioned mark trademark is identical or similar to the well-known mark. The well-known or the injured mark has a reputation in India. The use of the impugned mark is without due cause. The cause of the impugned mark amounts to taking unfair advantage of or is detrimental to the distinctive character or reputation of the registered trademark. So if these essential elements are satisfied, then that causes to dilution, or so dilution will be the cause of action. So there will be an infringement of their rights conferred. So basically what it happened was both ITC's and Philip Morris's products looked like the holding of hands. So the use of Namaste logo by ITC on its cigarettes became the reason for ITC's loss against Philip Morris. So Philip Morris had a similar logo much before ITC. So they filed a case and then later on they lost. The High Court observed that not only use of Namaste logo alongside the Welcome Group trademark, but also that the non-use of such logo on the cigarette packs makes the trademark dilution claim raised by ITC not sustainable. So not just there should be an existence of similarity as claimed. It should be actually what to say, a normal person, any common man should be able to not distinguish both the products. That is basically the simple test when it comes to trademark. A common man should not be able to distinguish both the products. So even if there is some similarity, if a common man is actually able to distinguish both the products, then there is no infringement of trademarks there. So now doctrine of dilution, there is dilution by blurring, dilution by tarnishment. So there are two types of dilution that can happen. Now dilution by blurring is defined as association arising from the similarity between the mark or trade name and a famous mark that impairs the distinctiveness of the mark. So when you impair, when you cause some harm to the distinctiveness of the mark, that is dilution by blurring. So only the problem of causing a harm to the distinctiveness is happening under dilution of blurring. Now, dilution by tarnishment is an association arising from the similarity between a mark or a trade name and a famous mark that harms the reputation of the famous mark as well. So, for example, if I am under the manufacturing of maybe clothes, I am under the manufacturing of khadi, and under my trademark, if another company has the manufacturing of lingerie, or maybe we can say manufacturing of liquor, then it actually affects the trademark or the reputation of my, right? So that is dilution by tarnishment. So not just the distinctiveness of the mark is also affected, but there has been immense harm to the reputation of my mark. So there are two types of dilution that can happen. One is dilution by blurring and dilution by tarnishment. In blurring, the distinctiveness is impaired. Under tarnishment, along with the problem of distinctiveness, the problem of harm to the reputation also occurs under dilution by tarnishment. And in other cases, Bloomberg versus Praful Saklecha delivered by Justice you can just read it later. Now, the Trademark Law Treaty was adopted on October 27, 1994 at the Diplomatic Conference in Geneva. This is another treaty, which is Trademark Law Treaty 1994. There are various treaties, so some of them you have to learn. According to Article 2, the treaty applies to marks for goods and services. Article 3 of the treaty contains an exhaustive list of information which may be required by an office in respect of an application for the registration of trademark. Holograms and non-visible signs such as sound marks, olfactory marks are smell marks, are also excluded from the scope of application under the Trademark Law Treaty. So, sound marks and olfactory marks are excluded from the scope of application under the Trademark Law Treaty of Geneva. So, whoever are the contracting parties cannot register a sound or olfactory mark, because they are not easily reproduced by graphic means, and because only very few countries provide for the protection of these marks in their national law. A mark must consist of visible signs, and as far as three-dimensional marks are concerned, only those countries that accept three-dimensional marks for registration are obliged to apply the treaty to such marks. So if you are a competing contracting party of the Trademark Law Treaty Geneva, then sound marks and olfactory marks are excluded from the scope of application for the international trademark registration. Now we'll look into some of the sections of the Trademarks Act 1999. There are 15 chapters and 159 sections and one schedule. One schedule is basically determining the classes, the product classes and the service classes. So when you file the application for the registration of trademark, you have to file based on which class of service or which class of product a particular product goes. Now, trademarks registry, the headquarters is in Mumbai. Section 5 and 6, an office called the Trademarks Registry has been established for the purpose of registration of trademarks, maintenance of the register, and matters incidental thereto. And there are around 4 other branches as well. Marks which cannot be registered are dealt under sections 9 to 12. There are absolute grounds of refusal and relative grounds of refusal for the trademark registration. Section 9 deals with absolute grounds. Section 11 deals with relative grounds. Section 48 to 53, Section 2.1 defines 2 types of permitted use of third parties. One is permitted use by registration of the third party as a registered user. The other is permitted use by third party without registration as a registered user, but subject to certain conditions. So third parties also can use, provided they are registered as a third party user. Sometimes under certain conditions, they need not be registered as well. Now, registration of trademark. The application must be filed at the office of the trademark registry. And it's not 6
Is there
registrar.
anything that we need to pay, ma'am, for every year, or how it is, ma'am? So for
It is
once it
actually
is
for 10
registered,
years. Yeah, the first 10 years it will be you'll get the registration for 10 years, and later on you can renew perpetually, almost perpetually you can renew. I mean, when it is a company has perpetual succession. If you've learned in the company law, a company has perpetual succession. So for example, if the trademark is for a company, then definitely perpetually you can actually renew the trademark. There is no limit. Initially it is for 10 years, given for 10 years. When the trademark is advertised in the trademark journal, then third party can oppose the registration of the trademark within 3 months from the date of trademark journal made available to the public. So when you apply for a trademark, then it will be made public, so that if there is any grounds to refuse the trademark registration, you can find that, and then the public can respond to it. Normally, the following person opposes the registration of trademark. 1. The owner of an earlier trademark application or registration covering a similar trademark for similar goods, or a person who has used the
ma'am,
same.
once we register, sorry to interrupt, ma'am. Sorry to interrupt. So once we
Yeah, no
register,
problem.
ma'am, so that will be audited against the previous trademark as well, right, ma'am? So then
No,
only they
it
will
will
go and
not be.
ask us.
Yes, I understand your question. Sometimes, if it has been existed, that previous trademark, even though it is not registered, if it has been existed for too long in a particular place, that people identify that product based on that trademark, even if you register a new one, it doesn't matter. The previous one would be still protected. So even if a trademark is not registered, there is something called passing of action. So that also is to protect the trademarks of, the unregistered trademarks. So as long as it is trademark is, as we've already discussed, it is basically to distinguish one product from another. So if people actually distinguishes the previous one, which is not the registered one, even if the new person who wants to register can actually register, as long as the previous unregistered person does not oppose to it. So only the unregistered person can oppose to this, but if they don't oppose, then definitely the new trademark can be registered, even if it exists. But they have the person who's already, even if irrespective of whether they have registered or not, they have the right to oppose. Am I clear?
Yes, ma'am. Thanks.
Okay. So if no objection is filed, or if the objection is dismissed by the registrar, he shall enter the trademark in the register, and a registration certificate shall be issued. The decision of the trademark registry is appealable to the IP appellate board. In the absence of opposition, a trademark is registered, and the relative certificate of registration is issued for 10 years from the date of filing of an application. So it's not from the date of giving the certificate. The certificate is valid from the date of filing of the application for 10 years. Now, what are some of the rights conferred by registration of trademark under section 28? The exclusive right conferred by registration is circumscribed by various limitations. These are: a right can be challenged on the ground that the registration is not valid. So rights are conferred by under section 28, and it can be challenged, or there are some limitations. Those limitations are: the right can be challenged on the ground that the registration is not valid. So to prove that the registration is not valid, you have to give circumstantial evidences and certain. Validity can be considered only in an application for rectification. It is subject to any conditions and limitations entered on the register. Any use of the mark beyond the periphery of such conditions and limitations is not protected by registration. So if you have registered the trademark for the tables, I am manufacturing, then I can protect the trademark only for that. So if I move into some other manufacturing, and I wish to apply this trademark for the next one as well, I'll have to register this particular trademark for that new product as well, or else it will not be protected under the Trademark Act. Just a moment. Registration will not operate against persons who are registered proprietors or of identical or similar marks. So if when you've actually registered the trademark, for example, some trademark already existed and you're actually done with the registration, then you cannot actually go you cannot actually oppose the registration. I mean, you have the particular period, right? So when you have a particular period, you can actually oppose because it is already there in the public. That the application has been filed, it is already there in the public domain. So if you want, you can actually oppose the registration during that particular 3 months period. The registered proprietor cannot interfere with prior uses of the same or similar mark. We have already discussed this particular thing. So even if you have registered a particular trademark, if an unregistered version of that exists, you cannot interfere with that unregistered trademark holder just because you have registered that particular trademark, because that person have been using that much before you. The registered proprietor cannot interfere with any bona fide use by a person of his own name or that of his place of business, or the use of any bona fide description of the character or quality of the goods. So these are some of the defenses we can say. In the case of a word mark, if in the course of time it becomes the name of an article or substance, then the rights conferred by registration ceases. This is based on the distinctiveness of the trademark. Now, registration of a mark is not a defense against an action for passing off. So, as I've already mentioned before, passing off action can be claimed for unregistered trademarks. So, even if in India, it is not mandatory that a trademark should be registered. So, even if you've not registered a trademark, you can file for a passing off action as long as you can prove that your product or your trademark has been in the market for a very long time and people actually distinguish your product from other based on that particular trademark. Now we look into the infringement of registered trademark. The registered user, if permitted by the registered proprietor, may take infringement action against third parties as if he is the registered proprietor. Under section 29(2) and 3, the following uses of the registered trademark which are likely to cause confusion or likely to have an association with the registered trademark: marks identical and goods or services similar, marks similar and goods or services identical or similar, marks identical and goods or services identical. So similar and identical are actually different. So it can be similar in the sense, there is some similarity. Identical, it is exactly like that. A suit for infringement of registered trademark must be filed in a district court having jurisdiction. So we are talking about the registered trademarks. So why there should be a registered trademark is so that you can have an easier protection of your right. Passing of action, it will be a civil suit. So it will take a long time, it will be time consuming, there will be a lot of procedures. You know how the code works. But if it is a registered trademark, it will be easier and easier to protect the rights that are conferred. A suit for infringement of registered trademark must be filed in a district court having jurisdiction or in a high court having original jurisdiction to entertain such suit based on the pecuniary jurisdiction. Nature of offenses, sections 101 and 102. In case of a criminal action for infringement or passing off, the offense is punishable with imprisonment for a term which shall not be less than 6 months, which may extend to 3 years, and fine which shall not be less than 50,000 and may extend to 2 lakh. The reliefs in a suit for infringement includes an injunction restraining further use of the mark, damages will be compensation, or an account of profits. So one of the relief is an account of profit. That means those period where you use a particular trademark, if you have actually accumulated any profits, you can actually account that to the you can remit that to the person infringed. I mean, the person whose right was infringed. And an order for delivery up of the infringing labels and marks for destruction or erasure. The infringement committed was if the infringement committed was innocent, only nominal damages will be awarded. So if you innocent in the sense, if you didn't know that that particular trademark existed already or something, then it will be treated as an innocent infringement. Only nominal damages will be awarded then. Passing off is a form of tort. Tort is a civil wrong. The law of passing off based on common law has remained substantially the same over more than a century, though its formulation has changed over the time. So before the registration of trademarks and all, trademarks still existed. So trademarks rights were infringed. So people used to go for passing off action before the registration of trademarks and all came into existence. The object of this law is to protect the goodwill and reputation of a business from encroachment by dishonest competitors. So some of the defenses are denial of allegation made by prosecution, acted without intent to defraud, but still you'll be you'll be awarded some nominal damages, nominal compensations. Use of mark permitted under the act or under any other law in force, acted inadvertently or under a mistake of fact, or that he had no knowledge that the trademark in question belonged to any particular person, provided the defendant had taken all reasonable precautions, or otherwise acted innocent. So we've actually covered almost all the topics under trademark. If you have any doubts, you can ask now. We'll take a break. Hi everyone. I hope you're all still here. So
Yes, ma'am.
yeah. So we looked into what all were the reasons for refusal before. So there are two types of reasons. One is absolute grounds for refusal, another is relative grounds for refusal. The absolute grounds for refusal is dealt under section 9, and relative grounds for refusal is dealt under section 11. So relative grounds for refusal are based on whether the mark you're trying to get registered was already registered before, and if there is any similarity, or based on whether there is any similarity, and based on the distinctiveness of that particular trademark which you're trying to get registered. So if there is any similarity to an already registered trademark, then there are certain relative grounds based on which you can refuse that particular registration. So that is section 11. So some more complicated one is absolute grounds for refusal. We'll look into absolute grounds for refusal. So if the trademarks are devoid of any distinctive character, that is to say, not capable of distinguishing the goods or services of one person from those of another person, then they will be refused to be registered. So distinctiveness is an absolute ground for refusal, or lack of distinctiveness is an absolute ground for refusal. Next is which consists exclusively or of marks or indications which may serve in trade to designate the kind, quality, quantity, intended purpose, values, geographical origin, or the time of production of the goods or rendering of the service or other characteristics of the goods or services. Again, this would be more of the descriptive. If the character is more descriptive, then that's also an absolute ground for refusal. Next is which consists exclusively of marks or indication which have become customary in the current language or in the bona fide and established practices of the trade shall not be registered. So if it is very much known to the people of that particular language, or if it is strictly related to that particular trade, the practices of that particular trade, then it will not be registered. But provided that a trademark shall not be refused registration if before the date of application for registration it has acquired a distinctive character as a result of the use made of it, or if it is a well-known trademark. So before filing the application for registration, if it has been there in the market and if it has earned the distinctiveness by the usage, by the prolonged usage, and it has earned the distinguishment among the customers, then it can still be registered even if it falls under these absolute grounds. So this is the particular loophole which is there, and that will be analyzed by the registry. Again, under absolute grounds for refusal, there are some more grounds. A mark shall not be registered as a trademark if it is of such nature as to deceive the public or cause confusion. It contains or comprises of any matter likely to hurt the religious susceptibilities of any class or section of the citizens of India. If it comprises or contains scandalous or obscene matter, or if it is prohibited under the Emblems and Names Act 1950. So if it falls under these particular categories, then it is absolutely not registrable. So if it belongs to the previous categories, these ones based on the distinctiveness and based on the kind, quality, and intended purpose, based on these things, if you try to register a particular trademark, then it can be registered, provided you have made it a well-known trademark. But if it comes under these particular ones, if it is to deceive the public or cause confusion, or if it if it is to hurt the religious sentiments of a group of people, or if it contains an obscene matter, All those things would be reasons to refuse the registration of the trademark. Absolutely. There is no any proviso for that. A mark shall not be registered as trademark if it consists exclusively of the shape of goods which result. We've already learned that trademarks can be mark which are the combination of shape of goods or combination of colors or something. But if that shape of goods results from the nature of the goods themselves, then it cannot be registered. So the shape of goods, shape of that particular good itself, which you are trying to register, those marks will not be allowed to be registered. The shape of goods which is necessary to obtain a technical result for that particular goods, then it is also not registerable. The shape which gives substantial value to the goods, those are also not registerable. And an explanation for this is important because for the purpose of the section, the nature of goods or services in relation to which the trademark is used or proposed to be used shall not be a ground for refusal of registration. So there is a small loophole in this particular grounds. It is that, for example, if we take again the study table as an example, if I'm registering the shape of a book as the trademark, then it is actually allowed because it is book is in relation to the study material. So it is in relation to the purpose of that particular study material. So it is not the direct shape of that particular goods, which is the table itself. So a book may be registerable. It's again under the discretion of the registry. But the above one, I mean the middle one, if it is of nature as to deceive the public, or if it is of obscene character, or if it is to hurt the sentiments of particular religion or community or section, all those will be absolutely prohibited to be registered. So I hope it is clear. Relative grounds, again, it is dealt under section 11, which can be easily understood if you read. So I'm not explaining that more. So if you have any doubts on today's topic, you can ask now. If you don't have any doubts, we can wind up the class. Shall we wind up the class?
Sure, ma'am. Yes.
Okay. Then we can wind up the class.
So do we have a class tomorrow also, or when will
Not
be
tomorrow, next Sunday, I think. Next Saturday.
Okay, not tomorrow.
Yeah. Not tomorrow.
Okay, okay, understand. Thank you very much.
Yeah.
Thank you.
Yeah.
Thank you. Thank you, ma'am.
Thank you, ma'am.